Hello everyone, my name is Satyam Shivaach and I'm working as a legal intern with LEXIS and Company. And in this video, we will discuss about winding up of a company under company's law. Winding up of a company is a process where the company's life come to an end and its assets are administered for the benefit of the creditors and its members. An administrator called liquidator is appointed and he takes control of the company's asset and pays debt and finally distribute any surplus among the members in accordance with their respective rights. Winding of a company can be due to numerous reasons such as hardship, bankruptcy, etc. The winding up of a company may be initiated intentionally by the shareholder or creditor or by a tribunal. The court, on hearing the winding up application, can either expel it or to make an interim request to it as a suitable. It may even appoint a liquidator for the companies till the application has been passed. And winding up order may be given by any court with or without any cost. Thus, it is a mechanism whereby the assets of a company are utilized for the advantage of its shareholders and creditors. The person who manages the entire assets of a company when it is in winding position is called as a liquidator. But with an enactment of Insolvency and Bankruptcy Code 2016, it has become difficult to apply provisions simultaneously and to declare precedents. And Insolvency and Bankruptcy Code has also included a lot of amendment to the Act, and the code provides a constructive framework for companies. With the passing of an Insolvency and Bankruptcy Code, there are now two modes of winding up, either under the Companies Act 2013 or under this code. Under the Section 2, Clause 94A, winding up of under this Act, that is the Companies Act or the Insolvency of the Bankruptcy Code 2016. Now let's see winding up under Companies Act 2013. Prior to the Insolvency and Bankruptcy Code, there were two forms of winding up. First being the voluntary winding up under Section 304 to 323 of the Companies Act, and the second being the winding up by a tribunal. The first has been deleted with the passing of the code and presently compulsorily winding up, that is winding up by a tribunal, is an existing method under the 2013 Act. The winding up by a national company law tribunal or compulsory winding up. The winding up by a tribunal may be conducted if any of the circumstances mentioned under Section 271 are fulfilled, and the tribunal may order for a winding up of a company on an application made by any of a person who is authorized under Section 272. A company can be wound up by the order of a tribunal. If a company by special resolution has resolved that the company should be wound by a tribunal, and if a company has acted against the interest of the sovereignty and integrity of India, the security of the state, or friendly relations with foreign state, public order or decency or morality, and if an application is being made by the registrar of any other person who authorized by the central government and the tribunal is of the opinion that the affair of the company has been conducted in a fraudulent manner, or if the company was designed for fraudulent or unlawful purpose, or if a person in the management of an affair of a company are guilty of fraud, misaffiance or misconduct, or in interest of justice, it should be wound up. The company has made a default in filing in the registrar its financial statement or annual returns for immediately preceding 5 consecutive financial years, or the company would be wound up if the tribunal is of the opinion that it is just and equitable that it should no longer remain in function. With the passing of Insolvency and Bankruptcy Code, grounds of inability to pay debt and winding up under has been deleted. Now let's see winding up by a special resolution under Section 271. The company's special resolution can be decided that it would be wound up or wound up by a tribunal. The resolution can be passed by any of the reason. However, tribunal must see that the winding up is not opposed to public interest or the interest of the company as a whole. The tribunal is also to take into account the possibility of the company to have a financial revival. When the company is incurring loss that led to the company to pass special resolution for winding up, this clause is based on the premise that the shareholder being corporate entities have the requisite skill to judge and decide as to whether or not the company should go for their existence. It is the shareholder who had formed themselves into a company, and therefore it is for them to dissolve the company. The directors are not entitled to file a finding a petition without the authority of a general meeting, and the director may file the application subject to the ratification of proposal. The company has to call general body meeting and pass a special resolution, including therein specifically their resolve for winding up by a tribunal and setting out grounds in an explanatory statement attached thereon explaining why the winding up of a company is needed. It must be noted that the court has a discretion and it is under not any obligation to alter the winding up. That is all for today's video. Thank you for watching. Please like, share and subscribe.